ப்ளே பண்ணிடுறீங்களா? கிருப்பையா இருக்கீங்களா?
இங்க நான் சிவா இருக்கேங்க, ப்ளே பண்றேங்க.
ஆ.
1 செகண்ட்.
நீராறும் கடலுடுத்த நிலமடந்தை கெழிலொழுகும் சீராறும் மதனமென திகழ்வரத கண்டமிதில் எக்கணமும் அதில் சிறந்த திராவிடனல் திருநாடும் தக்க சிறு பிறை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திறம்பியந்து செயல் மறந்து வாழ்த்துதுமே வாழ்த்துதுமே வாழ்த்துதுமே.
நன்றிங்க. அடுத்தது வந்து நம்ம இன்னைக்கு பார்க்க போகிற இந்த நிகழ்ச்சிக்கு முக்கியமான ஒன்று வந்து என்னென்னா, இன்றும் நாளையும் அப்படிங்கிற தலைப்பில் வந்து வி ஹாவ் அ சீஃப் கெஸ்ட் கமிங். அதுக்கு முன்னால் வந்து நம்ம பேரவையிலிருந்து இணைந்திருக்கிற செயலாளர் முனைவர் கபிலன் அவர்களை பேச அழைக்கிறேன். கபிலன்.
அனைவருக்கும் வணக்கம். வாரக்கடைசி நாளில் நேரம் ஒதுக்கி பேரவையின் கூட்டத்தில் இணைந்திருக்கும் உங்கள் அனைவருக்கும் வணக்கமும் நன்றியும். பேரவையின் மாற்றுத்திறனாளிகளின் மேம்பாட்டுக் குழுவை சார்ந்த தலைவர் திரு சக்திவேல் ராமசாமி, மீனா கலியப்பெருமாள், மகேந்திரன் சுந்தர்ராஜ் உள்ளிட்ட குழுவை சார்ந்த நண்பர்கள் அனைவருக்கும் வாழ்த்துக்கள். இந்த அருமையானதொரு நிகழ்வை ஏற்பாடு செய்திருப்பதற்கு நிகழ்ச்சியின் சிறப்பு விருந்தினர் சட்ட வல்லுநர் மேன்மை மிகு நீதிபதி திரு ஜெயராம் அவர்களுக்கு மனமார்ந்த நன்றிகள். சிறப்பு தேவையுள்ள குடும்பங்களுக்கான சட்ட பாதுகாப்பு பற்றி அறிந்து கொள்ள உங்களோடு நானும் ஆவலாக இருக்கிறேன். தமிழால் இணைவோம், தமிழராய் வாழ்வோம். அனைவருக்கும் வாழ்த்துக்களும் நன்றியும் சொல்லி அமர்கின்றேன். நன்றி, வணக்கம்.
நன்றி கபிலன். அடுத்தது வந்து நம்ம நிகழ்ச்சிக்குள்ளே போயிடலாம். முதல்ல வந்து இந்த நிகழ்ச்சியை பற்றி ஒரு சின்ன தேவை என்ன அப்படின்னு பார்த்தீங்கன்னா, இன்றைய தேவை ஒரு சமத்துவமான ஒரு environment. What we really need is like whatever we have, the kids may be like good or bad, or they have their special kids or special need, or like they may be like kind of like intellectually good or disabled, doesn't matter to us. We have to give an equal opportunity to everybody. So today's session, whatever we have, like we have a chief guest here, D.J. Jayaram sir. He is a judge and attorney. He is going to come and deliver a speech about like how we can improve or what we can do with if you have a special need kids and whatever the family need, whether they need any legal protection or like if they can able to do any kind of a help that government can provide. So all these things he is going to talk about that. I think Ganeshan is going to, when he introduces our chief guest, he is going to talk about more. But first of all, thank you for all the participants who want to eagerly waiting for to listen the chief guest is talking. So let me give that to Mr. Ganeshan to give an introduction to our chief guest. Ganesh.
Thank you, Shaktivel. Hope you all can hear me. Kids are always special, and special kids are even more special. I know this because I was one when I was a kid. But what about their future and their families, right? So to answer the big question that we all parents have, we have our special guest with us to answer all those questions. Thanks, Mr. DJ. DJ has his own law firm and helps special need families across all of Georgia. He also serves his community as a part-time magistrate judge of Gwinnett County. Prior to establishing his own practice, DJ was with large firms, healthcare groups. In addition, His expertise includes serving as the Deputy Director for Legal Services with the Georgia Department of Community Health and as a Georgia Administrative Law Judge with the Office of State Administrative Hearings. In that role as a judge, DJ has presided over Katie Beckett. We all know about that, right? So we all have faced some challenges in the Katie Beckett and the Medicaid application process. And he has presided over that. And now on COMP hearings, the NOW, COMP hearings, uniquely positioning him to help special need families when he opened his private practice. So without much further ado, I would like to invite our chief guest to present his topics. Please welcome Mr. DJ.
Thank you for having me. I appreciate the opportunity to speak with you about issues that are near and dear to my heart. I'm going to share my screen with you. And today, what we're going to talk about, the legal tools that we can use as special needs families, special needs parents, to protect our children, both now while we're here and into the future when we are no longer around to do all the things we need to do for them, who will do them in the future. And so we're going to address all of that today. So the topics we're going to cover today, we're going to talk about special needs trusts. We're going to talk about able accounts, or sometimes called stable accounts. We'll talk about wills. Obviously, people without special needs have wills as well, but there's some special and unique considerations that go into a special needs family's will. So I'll just touch on that. And then we'll talk about the major players in a good special needs estate plan, successor guardians and successor trustees, and how you choose them, how those roles fit together to maximize protection, not only for the trust, but for the child themselves. And so I will try and address all of that in the time we have today. Just a little bit, as was said before, I've worked with the Medicaid department here in Georgia for many years. Been 27 years of private practice. I also work as a judge in Gwinnett County. But this is why I do what I do. My son Kai is on the autism spectrum. He also has a condition called Williams syndrome. And what that translates into for us is a pretty serious intellectual disability for him. He will be with us the rest of our lives, and we do have to plan for him after we're gone. And so everything I'm going to talk to you about today, my family has had to address ourselves. So when we get to the question and answer period, if you have any questions about anything, there is no off-limits topic. I'm glad to share with you what I have done for my family, if that will help you. Today's presentation is just for general education purposes. Understand that we have attendees from all across the country. And so this is just meant for general information. Your particular state's laws may differ. So again, we'll be addressing special needs trusts, able accounts, and the will as the major documents. So why do you need a special needs trust? A special needs trust is meant to protect your child's eligibility for what we call resource-based government benefits. Well, what are those? Those benefits are Katie Beckett, SSI as an adult, Medicaid as adult, and in Georgia, we call it the NOW and COMP waivers, but nationally, it's known as the Home and Community-Based Services waivers. So those waivers that mostly adults get, where services can be provided in their home or sometimes providing housing. But all of those benefits are what we call resource-based benefits. The reason it is called that is, at least in Georgia, the child, and nationally, the child or adult child cannot have more than $2,000 in their name and continue to qualify for these important benefits. So that raises the question, as we get older or if we pass, where do we leave the money and assets for that child's future support so as not to interfere with them getting those benefits? Well, if you leave it to the child directly, they have more than $2,000, and their benefits will be terminated. Well, that's where the special needs trust comes in. Anything you put into a special needs trust, the government ignores in determining your child's benefits, whether as a minor or as an adult. The government ignores everything in that special needs trust. The second benefit of the special needs trust is, of course, it keeps money out of your child's hands, which means if anyone is seeking to take advantage of them as they get older, try and make use of their money, make use of their assets, well, the child doesn't always have direct control of those assets. The trustee who controls the trust on behalf of the child controls what's in the trust. So there's some protections there as well. Another benefit in many trusts is what we call creditor protection. What creditor protection is if you start a special needs trust and you put some assets in there for your child, say you put $10,000 in it. Well, then if you get sued or the child gets sued for some reason, that $10,000 in the special needs trust is protected from any judgments because it doesn't belong to you, does not belong to the child, it belongs to the trust. So anything in the trust will be protected from creditors. And finally, one of the big benefits for a special needs trust is you get to choose who the trustee will be. Now, while the parents are around, they are obviously the initial trustees. But then after we're gone, you can set a plan of who will control the trust. You can set backups. You can create mechanisms within the trust by which successor trustees are chosen. Because one of the unique things about a special needs trust, as opposed to most typical trusts, is it will most likely have to last the lifetime of the special needs individual. So we're talking about a trust, if you have a young child, that can last 60, 70, 80 years. And so we have to make allowances in the trust for the people who will control it after we are gone. There are three kinds of special needs trusts: first person, third person, and pooled. Now, the first person special needs trust is called first person because it is funded with money or assets that belonged to the special needs individual. So it belonged to them, and then it was taken out of their name and put into the first person trust. Now contrast that with a third person trust. It's the exact opposite. It is a trust that is funded from sources that never belonged directly to the special needs individual. It belonged to mom and dad, or grandparents, or any other source. And it will flow directly into the trust for the child's benefit. It will never legally hit the child's hands and never legally belong to them. Now, the big difference between the two, the pros and the cons. The first person trust is to be avoided if possible, because the rules around a first person trust nationally is anything left in the first person trust after the special needs individual passes away. Medicaid can take what's left in the trust to the extent they've paid for any services for that individual over their lifetime. Well, that's a big problem. I mean, if you pass away and you're funding a special needs trust for your child, and you have other children to consider, or you want to leave those funds to charity or any kind of organization you choose, that's not going to happen in a first person trust. Medicaid will take what's left when the special needs individual passes away. Now, sometimes a first person trust cannot be avoided. When money did end up in the child's name, or if they're a direct benefit to them, public assistance money coming in, grandparents sending them money, well, that they owned that And so we can't afford the first person trust. The preference is the third person trust. Again, money and assets never belong to the child. It will flow from the funding source directly into the trust. As long as it does that and never legally belong to the special needs individual, at the end of that individual's life, anything left in the special needs trust goes wherever you have decided it goes as the creator of the trust. So it can go to your other children. It can go to grandkids. It can go to aunts or uncles. It can go anywhere you choose to go. So the preference is always a third person special needs trust. Now, there is a third kind of special needs trust out there called a pooled special needs trust, Pooled. It is called a pooled special needs trust because it is a giant special needs trust already created by a trust company or a bank. And in this kind of trust, you or your child or your family member will open up an account within the giant special needs trust. So the trust is not specific to your child or to the individual. It is a giant trust that you're just opening an account in for your use. The benefit of the pooled trust is upfront, it might be a lower cost to use than having a lawyer draft a first or third person trust for you. Because the first and third person trusts are drafted specifically for one person, for your child, for your loved one, while the pooled trust is drafted for a large group of people. But the benefit of the pooled trust is, since you're not paying a lawyer to create a specific trust for your child, the upfront costs are less. The other benefit of the pooled trust is you have lots of professional management under one roof. You have benefits attorneys, you have CPAs, you have financial planners. All that expertise is under one roof. It will handle filing your tax returns, any SSI reporting obligations. So lots of benefits there. The biggest drawback to the pooled trust is over a long period of time, it tends to cost more than having your own trust drafted for your child. And that's because the pooled trust is not doing those services for free. You have to pay a fee to that trust company. While first or third person, since you are choosing the trustees, who can be a friend or family member, I've never seen a friend or family member take any compensation for handling a special needs trust. So in the long term, there could be savings. The other drawback to the pooled trust is you're not choosing the trustee. It's that company. So it's not somebody who necessarily knows or loves or cares about you or your child. It's a business. And so to the extent you would like somebody who knows and loves you and your family to manage the trust in the future, you would need to create a specific trust for your child. If you don't mind having a corporation running the trust and for the benefit of having all that professional management, then maybe a pooled trust is right. But remember, with a first or third person specific trust for your child, the trust can hire that expertise. It can hire a CPA. It can hire a financial planner and attorneys. So it's not that it doesn't have those expertise. It just has to go outside to hire them. But those are the three kinds of trust that are available. Third person is the one you want to use, if at all possible. If you can't avoid a first person trust, then that's the second option. And then a pooled option is an alternative to both of those. A pooled trust can be first or third person. Now that we've know what the different trusts are, what can you use a special needs trust for? Under the Social Security rules, you can use a special needs trust for any purpose without affecting your child's eligibility or receipt of benefits. except shelter. Shelter are things like mortgage payments, rent payments, property taxes, costs of paying for shelter. I would not worry about this too much because I'm going to explain the workaround in a moment. But if you do pay out of a special needs trust to supplement for shelter, the consequence is a potential reduction of any SSI cash benefit your child gets up to 1/3. So if they're receiving $900 in SSI cash benefits each month, and you spend $300 a month out of the trust to supplement for living expenses, well, there's going to be a 1/3 reduction from the 300. So the $900 would become $800. I just want you to understand that's a consequence of paying for shelter directly out of the special needs trust. But don't worry about that because I'm going to discuss the workaround here in just a moment. And the workaround is the ABLE account. Some states will call it a stable account. I believe all 50 states have a version of this. Well, what is a stable account? Well, a stable account works the purpose of a stable account or ABLE account is very much the same as a special needs trust. It is to protect the special needs person's eligibility for resource-based government benefits like SSI, Medicaid, Katie Beckett, and home and community-based services waivers. So that way it's the same. It's very, very useful because friends and family can contribute to it. Anyone can contribute if you want. Its tax advantages. That's a big benefit to it. And I'll talk about that in a moment. But remember, the government ignores everything in the ABLE account, just like it ignores everything in the special needs trust. Another benefit of the ABLE account is its easy access to those funds. A trust is harder to access. Any money in a trust, whoever is trying to access the money has to contact the trustee, and then the trustee has to access the funds and use it for the individual. With an ABLE account, the special needs individual can have direct access to that money. So if you have a higher functioning individual with special needs and you want to give them some money for spending use or expenses that they themselves can learn to control, they can do that with an ABLE account. They cannot do that with a special needs trust where they will not have direct access to the trust. It would have to go through the trustee. ABLE accounts are very, very easy to open. As I said before, special needs trust should be drafted by a lawyer if you are going to have an individual one for your family or for your loved one. An ABLE account, you can open up an ABLE account online. It takes just minutes to open. So very, very easy to open and use. So to use the ABLE account properly, you have to understand how it differs from a special needs trust. The very first thing you need to understand about the ABLE account is just like a first-person special needs trust. At the end of the special needs individual's life, anything left in the ABLE account, Medicaid can take. So there is Medicaid payback in a first-person trust and in an ABLE account. Remember, no Medicaid payback in a third-party trust. Number two, there are limitations on how much you can put into an ABLE account each year. This year, it's $19,000. That amount goes up a little bit if the special needs individual is earning income. It goes up several $1,000s. And at $100,000 in the account at any one time, any SSI cash benefit received will be suspended. So to the extent you want to maximize your child's SSI income, you've got to keep that ABLE account under $100,000. So as you creep up to 100, you can use those funds for any purpose to support that child and bring it back under 100. So ABLE account can be used for any purpose. Couple other important differences. A special needs trust can hold anything. It can hold money, it can hold accounts, it can hold a home, it can hold ownership in a business or rental property. It can hold just about anything. An ABLE account can only hold money. So you put money in the ABLE account. Most ABLE accounts have investment options in them you can invest in, like mutual funds. But you can't put things like a home or rental property or ownership in a business into an ABLE account. You have to use a special needs trust for that purpose. You can use the ABLE account for shelter. Remember I said there's a workaround that if we don't want to use money out of the special needs trust for shelter, thereby reducing some cash benefit, what do? Well, you can always put money from the special needs trust directly into the ABLE account and then pay for shelter out of the ABLE account without any reduction, because the rules and regulations, the law around the ABLE and the special needs trust are different. So while there's a penalty for paying for shelter out of the out of the special needs trust, there is no penalty for paying for shelter out of the ABLE account. Okay, so there's a strategy there for us to learn, and a strategy we also want to pass on to our successor trustees if they ever need to step into our shoes. One of the biggest differences between the ABLE account and a special needs trust is number 5 here, and that is the tax treatment. A special needs trust is taxed every year on its income, just like a person would be. So if you have $100,000 initial funding in the special needs trust, and it earns $10,000 in income in 2025, well, that $10,000 will be taxed. Special needs trust tax rates are not great. They tend to be more aggressive than our personal tax rates. So always check with a CPA before you fund your special needs trust. Now, one of the big benefits of that ABLE account, and it differs from the special needs trust, is any income in an ABLE account is tax-free. So it functions very much like a Roth IRA or a 529 college savings plan for tax purposes. So no income tax year to year, it can compound year after year. And then ultimately, when you use those funds for the special needs individual, it remains tax-free. So it's not tax deferred, it's tax-free. So big tax difference between the two. The bottom line is most families have both, a special needs trust and an ABLE account, and they work together to maximize the benefits for your loved one. So let's talk about the will. A will, like I said, everybody should have one, but there's some special considerations for families that have special needs children. One, of course, the will basically is the roadmap of your wishes for your assets when you pass away. The hard decisions for us as special needs parents is the flow of your estate, especially if you have more than one child. If you have one special needs child and one typical child, well, the special needs trust is for the special needs child. The typical child should have their own trust. And so in our will, we have to determine, or in our plan, we have to determine if we're going to leave our assets to the children how are we going to split our estate between the two? Because the special needs trust is only for the special needs child, typical trust only for a typical child. So if we were to pass away in the next 5 years, how are you going to split your money and assets between the two children? I know we're always taught to be fair and we love our children the same. And so it makes sense to leave things 50-50. I always encourage my clients to think beyond that. Okay, we have to recognize that our special needs child may have more challenges being self-sufficient throughout their lives than our typical child. And just acknowledging that, do we need to fund their trust differently? That's a hard question. It's one of the hardest questions in a plan. A lot of that has to do with the level of functioning of the special needs individual, has to do with the size of your estate. How much money are you leaving to the kids? It also has to do with your personal risk tolerance. Because right now we have SSI, Katie Beckett, Medicaid, home and communities waivers, and those pay for things. So are we going to assume that those benefits will be there in the future and fund the trust accordingly? Or are we going to prepare for the worst case scenario, which is those benefits will not be there throughout our child's life, and fund it so the trust has to pay for those things, which means we would have to fund the special needs trust with more money to make up for that shortfall. There is no right or wrong answer to this. There's just your own personal decision on what is best for you and your family. The second big decision for special needs families would be, what do we do with your primary residence, where you're living with your special needs loved one? Your primary residence, it's not just a piece in your financial picture, it's a home. And so one thing I do suggest to my clients is make your initial decisions in your will based on an assumption both parents will pass away in the next 5 years. That makes your initial decision-making easier. If we start looking 20, 30 years down the road for our initial decision-making, people get stuck and they end up not making decisions. So just to make it easier for yourself, look at it through a 5-year window. So with your primary residence, if you have a child who's younger and mom and dad pass away, if the child remains in the home, you keep the home, and your guardians and caregivers come to the home, live there, or take care of the child in that home, think about all the things that can stay the same. School system can stay the same. Primary care physician, dentists, therapists, specialists, neighbors, friends, all those things can stay the same. But if your child moves after you pass and lives with a guardian even an hour away, or a state away, or a country away, all those things have to change. And we know as parents that it was very hard to find good doctors and therapists and specialists to help our child. Do we want to start over in a different area? And again, no right or wrong answer. You just have to think it through and ask all those questions. And whatever you do decide, we want to make sure your will and your trust reflect your decision. Because a basic will for a typical person just gives ownership of the home. It doesn't dictate how to use the home. So if you want to maintain the home for your special needs child, most likely it will be placed in their special needs trust after you pass, and the trust will manage the home on behalf of the child. Okay, but really think through, what do we want to do with our home if mom and dad are gone? The next big decision, of course, will be successor guardians. That if something happens to mom and dad, who is going to step into their shoes to become the caregivers for the special needs individual. And finally, a will minimizes family conflict and drama. For some reason, when people pass, families fight over assets, over money. The more specific and detailed you are in your will of how things are to flow and how things are to work, the less fighting there will be. So when you go and get your wills done, just remember to be detailed. Ask questions. Don't just count on your attorney and the questionnaire. Push a little beyond that and ask questions. So we have the will, we have the trust, we have the ABLE account. Those are the major tools. Now within the trust, it is important to make sure that after mom and dad are gone, that you are selecting knowledgeable trustees to manage that trust for your child. And what does that do for us? Several things. One, it ensures protection of the assets in the trust. It ensures that it's invested wisely. It's going to ensure that this trust is in compliance with Social Security regulations and state law to make sure benefits are protected. That's a lot of stuff. And so that means you have to have a trustee who's at least knowledgeable about these things, but more importantly, they know when to ask for help. There is not one person, you're not going to find one person who knows all of this. But you need to know somebody who will become the quarterback of the trust, and then they'll be able to retain expertise as needed. But that knowledge, the fact you're sitting through this presentation, your successor trustees would not have done that. So make sure in your estate plan, in the booklet you'll get from your attorney, in the binder, there's an education section for your successor trustees. This is how a special needs trust works. This is what you can and cannot use it for. This is what an ABLE account is. Here's the strategy on how to use the trust with the ABLE. And here is a list of people you can call, list of professionals that you can ask questions of. We have to give that information to our successor trustees because they will most likely not have it when they step into your shoes. We do always suggest that your successor guardians and your successor trustees, so people after mom and dad, whoever's managing the trust for the special needs individual, and whoever is their legal guardian, are different people. The reason for that is it creates checks and balances in those roles. So what do I mean by that? So the role of the trustee, remember, the guardian exercise the legal rights of the individual on their behalf, who they're guardian over. One of those rights is to sue the trust or the trustee if something happens, if something's going wrong with the trustee or the trust. Well, if the trustee and the guardian are the same person, who's watching? What protections have we built in? So one of the main protections is to split the role. One person is trustee, different person is guardian, and they work together to support the special needs individual. It's also a benefit because it doesn't put all the work on one person. Okay, there's a team there to assist. We also draft our trusts, and I'm sure there's other attorneys out there who do this, so that we require our trustee or someone on their behalf to visit the special needs individual in person on a regular basis throughout the year. For my son, it's monthly. Because what if it's the guardian who's not doing the job anymore for whatever reason? That's not that they turn bad. It could be dementia or Alzheimer's or divorce, depression. It can be any number of things. I'm not willing to risk my son's future welfare on just trusting. And so the way I address that is the trustee visits my son every month. So if the guardian's not doing their job and the trustee visits my son and he's gained weight or lost weight, or my personal nightmare is he has a bruise on him, I make sure someone else is watching. So creating checks and balances are really important. If you do not have enough people to fill the guardian and trustee successor roles after you pass, you don't have enough people in your life or enough people you trust, that's okay. But there are other ways to build in those protections other than splitting the role. You can name co-trustees, two trustees who serve at the same time. Then the co-trustee visits the special needs individual while the other co-trustee, who's also the guardian, is filling both roles at the same time. You can also draft into your trust a role called a trust protector. Well, what does a trust protector do? A trust protector can do anything we tell them to do in the trust. What we do is ask them to do an informal audit of the trust a couple of times a year, make sure nothing big is going wrong. If nothing's going wrong, no problem. If something is going wrong, we allow our protector to remove the trustee without going to court, and then whoever you have selected as the backup will move up into that role. So the protector doesn't have the ability to choose the backup. You've already done that. So you see the concept, always multiple sets of eyes on the trust and on the individual. That's how we build in protections. The last topic I'm going to talk about today is guardianship, powers of attorney, or supported decision-making. We know for individuals who are minors, in Georgia, it's anyone under the age of 18, they have to have a guardian because they're minors. In most states, people, when they turn 18 years old, become adults. And they have all the rights and responsibilities of an adult in that state. Now, once your child reaches adulthood, most states require that if mom and dad want to maintain decision-making authority over that child, that they get guardianship. It is not automatic in most states. You have to go through a guardianship process because now the court is giving your adult special need child's rights, taking it from them and giving it back to you. It is not automatic for an adult. It is automatic for a child. So this is the legal standard in Georgia. It differs state to state, but it's basically when an adult cannot make reasoned decisions about significant things like their health and their safety and their welfare. They have an inability to make those decisions. A couple practical decision-making things, and I'll try and go through this to meet my deadline here. Number one is medical decision-making. Well, do you want to have final say-so on your adult special needs child's healthcare choices, or do you want them to have it? Second are contracts. In most states, one of the rights taken away in the guardianship process from the special needs individual and given back to mom and dad is the ability to sign a contract. Well, if you don't want your child to be able to go out there and sign something, then guardianship is an option. And lastly, I always urge people to think about interaction with law enforcement. Because in guardianship, a court has already adjudicated the fact that special needs adult individual cannot make reasoned decisions about important things. Well, if your child, has behavior issues or touches people too much or grabs people or flails around sometimes, and law enforcement gets involved, Well, if there's guardianship in place, a court's already said he can't make reasoned decisions. So if he can't make reasoned decisions, how can they form criminal intent? So some real protections and considerations in guardianship. When you choose a good guardian, ask a lot of questions. How old are they? A lot of people choose the grandparents. Well, how old are the grandparents? What is their health like? Right? I mean, we tend not to get healthier as we get older. Do they have the time? Do they know how to care for your child? Where are they? Are they close by so the child can stay in the same school or with the same programs, or are they far away? We got to ask those questions. Finally, you do need to educate your successor guardians on how to care for your child, whether minor or adult. Being a special needs parent is not intuitive. It's learned. And it's learned the hard way. It's over a lifetime of learning about the needs of your particular child. No one else in the world knows that but you. So we always say to draft what's called a letter of intent or letter to the guardians, or make a video of all the tips and tricks that you've developed over your child's lifetime to care for them. Bedtime process, bath time, taking meds, who are the providers, what are their sensory triggers, where do you want them to live, what schools do you want them to stay into. You have to write all that down because they won't know. So for example, for my child, when we brush his teeth, he hates it, has sensory issues in his mouth. So when we brush his teeth, we have to sing a song. And it's not just any song, it's a particular song. And when he's had enough, he'll put up his hand. We will stop brushing his teeth. And when he's ready for us to start again, intellectually, he can't say, I'm ready for you to start again, but he will say, sing. Mommy, daddy, sing. And that's our clue to finish brushing. If we don't pass that on to our successor guardian, and he or she walks in and tries to brush his teeth without knowing the trick, his anxiety is going to go up. And he's going to know these people don't know how to care for him. So all that information in our brains, we have to capture it. And we suggest you update it every New Year's Day. Okay. The initial drafting takes a while, but updating it each year is not too bad. Just a quick word on the alternatives to guardianship. Powers of attorney are one. That's where your child maintains all of their rights, but are just authorizing mom and dad to exercise those rights on their behalf as their agent. Some states have supported decision-making, where again, rights are not taken, but a structure is created where a group of people try to assist your child in making decisions. The real bottom line on all this is who's the final decision maker? Under guardianship, it remains mom and dad. Under power of attorney, it is the child, since you are working as their agent. So I think that's the end of my time. I want to stay on schedule. So I'm glad to take any questions.
Thank you so much, DJ, for detailed explanation of these three critical topics. Thank you so much. We have a few questions on the chat. Shaktivel, you want to go through?
Yes. So first question we have from Chris. Is this applicable to a kid who is not a US citizen, but staying here in H4 and with the H1 parents? So basically he's talking about like, he's not the kid is not a US citizen. Is it all these things going to be applicable to that H1 or dependent kids too?
Not at this point, with those benefits not necessarily being available. So what you may want to consider is a regular trust for your child, and consider your state, consult your state law to see if any benefits may be available, because it will differ from state to state.
Thank you. And then one more question is like, so you talk about like the 19K limit for like the tax limit, right? For the gift you can give. So is it like the 19K get like, for example, is it like to the kid or like as a person, I am gifting the 19K to the kid and then my wife can give another 19K? Is it going to be, or it's 19K is that?
Exactly. It's 19K into the ABLE account each year, and that's it.
Okay, it's not the how many amount we are getting. Okay, perfect. And then is this like, can we able to make an able accounts to the dependents? The same again, it comes back to the first question. Is just a dependent? He's not a US citizen. Can we create an able account to that?
You can, in anticipation, maybe if permanent residency is established, or citizenship is obtained, then everything in the ABLE account is still protected. But yes, you can open up an ABLE account.
Okay, so basically I can open an able account. Even my kid is a H1 dependent, so I can able to create one. Okay, perfect. And then another one is like the SSI money we are getting it, right? Some amount from SSI can be used for fund the able account. Can we do that? The money from
Yes.
SSI can be.
Absolutely. So the SSI income or even SSDI income that's coming belongs to the child. And so you can either put that in a first party trust, which we don't really want to do, or you can put it in the ABLE account because that is a first party asset. So it's so SSI, SSDI money is first party. So you can use the ABLE account for that. So what most people do, they have a checking account to receive that government benefit. They then pay for whatever the child needs that month out of that checking account, for daily, monthly use. If that checking account starts bumping up against the $2,000 limit, then they transfer it into the ABLE account. The reason we do it that way is if SSI ever comes to audit that family, the family can show the money went into that checking account and was paid out. That's all that was in there was SSI. But in an ABLE account, if you put 5,000 in and I put 5,000 in and grandparent put 5,000 in, and then some of it's from SSI money directly, it all gets jumbled and that would make an audit very difficult.
Okay, so basically the SSI money is auditable, so we have to show how we are spending it. So it needs to be like separate. Okay, perfect. But you can do it. The answer is like you can do it, but if it is putting it, it's kind of like little.
Yeah, I just wouldn't put it directly into the ABLE account.
Got it. Got it. And then the another one you talk about the guardianship, right? The case like we can make a trust member or a guardian can be a person from outside America.
It can be. It can be. Whenever I get that question, I always just say, well, let's understand that if the guardian's going to be someone outside of the country, is the plan for the child to move to that country? Right? I mean, if that's the case, then that's fine, but there is no citizenship or visa exception for someone from another country just to move here because they were named as guardian.
Just to add on to that question, one is like they can be, but if I am putting somebody as my my uncle or my dad as a guardianship to my kid, is there any like limitation? They had to come and visit, like guardians has to visit that kid or the special need kids in a regular basis, or no need?
Not necessarily. To understand, most courts, and differs state to state, but most courts that will appoint the guardian, even if it's named in your will, their job is to do what's in the best interest of the child. And so if you've chosen someone in another country who is never going to visit that child, what kind of guardianship can they really provide? I think that's what a risk we run, that if the court asks that and there's somebody here, a cousin who says, well, I'll be guardian and I'll be right here, there's always the chance the court can side with the cousin.
Then the another one question is like, if the special need child is a physically or mentally disabled, needing a constant support and attention, no one that we know of would be ready to take care of him. Is there any other option? Basically, like since like It's not easy, right? So because like as a parent, we know, but we are expecting the guardians and other people to take care. But if is there any other option?
So let me answer that by first saying it's one of the hardest things we'll do as parents is we have to choose somebody. Because if we don't choose somebody, a court will choose somebody. And that court will not make a better decision than you will. So you have to make the best decision from the people we have to choose from. But to answer the question, there are some states that have what are called corporate or professional guardians. It just depends on your state law. I know Florida is one, Arizona is one. A lot of places with retirement populations can have what are called professional guardians. Georgia, where I live, does not. And so, you got to look at your state law. But again, just to reiterate, whenever I see these professional or corporate guardians out there, you hear some horror stories about that. And so what I would rather see is a friend or family member as guardian. And then through your trust that you've created for the child, make sure they have all the supports they need in place so that they won't be overburdened or overwhelmed with taking care of your child.
And I believe like in summer because we are looking for like a homes, the elderly homes, the same way there special homes available. We can
Yes.
pay and then they will take care because like after
Yes.
we are gone, they are alone.
Yes. So most states, that home and community-based services waiver that I mentioned, that's the national name for it.
Okay.
Georgia's version is called the Now Comp waiver. What that is, that depends on the age, but for a lot of states, it's as the kids get older into adulthood, where mom and dad either pass away or reach an age they can't do everything they need to do. Most of those waivers will pay for group housing. So what that looks like in many places is a regular residential home with maybe 2 or 3 special needs individuals living in it, along with a house manager, 24/7 supervision, and extra supports being brought in during the day, transportation, meal assistance, laundry assistance, all in that home. So look for that home and community-based services waiver in your state.
Thank you. Another one is like it's morely about the visa related because normally we have like if the kids turns regular kids, right? If the kids turns 21, will that since it's a special need kid, what will happen? Because like that they are not part of dependents, right? Because they are not comes under student category. How it will work? Do you think you can?
So honestly, that's a little bit outside of my
Got it,
my
got it.
area of expertise.
I understand. And then the other one is like if we so we have a trust. One of the parent was asking, they already have a trust for our kid, their kid. So will that guardianship, if they are going to start the guardianship process, will that guardianship take over the trust or
No.
how that the guardianship and trust?
Yeah, so no, they're completely separate jobs. So the court will appoint the guardian, but whoever you've chosen to be the trustee is the trustee. The court does not get involved with that unless everybody you've chosen has passed away and there's no mechanism. But even then, most courts understand not to name the guardian also as trustee unless it's, a parent.
And can I have a able account for my special child and separate 529 for my other child that you can do?
Absolutely, yes.
Okay. And for creating an able account, is there any age limit? The kid needs to be the certain age or we can do it?
Not that I'm aware of. I know we created my son's able account when he was 3. So unless there's a state-specific limitation, I'm not aware of any national limitation.
And one more is like, I think we are almost like crossing our time, but I'll just quickly scan through. Is there any other questions? So
Sure.
one question is like, if the kids turn 18, is there any government provide anything special? Anything they are giving any benefits to the kids or like these kind of kids?
So when you turn 18, that's when you should apply for SSI for your child as an adult. And again, it's different from state to state, but in most states, when you reach 18, if you get SSI, that automatically comes with adult Medicaid and also comes with a SSI cash benefit. Right now, it's around $957 per month to the child. The other thing to remember is that adult Medicaid opens the doors to that home and community-based services waiver. You have to be Medicaid eligible to get to even apply for those. So very important to apply for SSI when your child turns 18.
That's good. And then one more is like,
I
since
have a question. Hello.
yes, go ahead.
Yeah, I have a question. Sir, my elder one is 7 years, and he is having high functioning autism. What is the benefit he is qualified for, sir?
It's going to depend on your state, but most states have a Katie Beckett program. Katie Beckett is a Medicaid program where the state ignores mom and dad's income. Because, for most families, you're over income for Medicaid. But if your child has either certain diagnosis or certain level of need, meaning functioning deficits, then your child can qualify for Katie Beckett and Medicaid coverage. The rest of the family still will not be eligible, but Medicaid can pay for multiple therapies, act as a secondary health insurance to your primary insurance. So check your state Medicaid program for a Katie Beckett waiver.
Can we open the able account for him, sir?
Yes.
He is 7. Okay.
Absolutely.
And what is the immigration benefit we can avail with the special kids, sir? He is a citizen here.
I do not.
Let's say the parents are in H1, right? So can they stay because the rule, right? If there is no job, we have to leave for 60 days time.
Let me put it this way. I don't really know the answer to that question, but based on the current administration, I'd say no. If it's there now, it's not going to be there soon.
I think Ganesan wants to talk.
Yeah.
Yeah.
So just want to add, the able account is available in 48 states. So, and you can also open an account in other state too. And some states have state tax deduction for the amount that you invest. So it gives triple tax benefit. In some cases, it acts as like the HSA account where the amount that you put is also tax deductible and the earnings that grows out of it is also tax free. So it has the triple tax advantage only when it comes to the state level, and it varies from state to state. And recently, originally it was only for the US citizens, but if you have kids who has an SSN, they are eligible to open the able account. So that I want to add. And I have a question to Mr. Jayaram. So a kid can have both able account and a 529 college savings account, right?
Correct.
Correct. So it doesn't stop the parents to create one.
No, and down the road, they can even roll over the 529 into the able without any tax consequences.
Correct. And also the one another question is like, can the able account be opened with trust as the owner? A special need trust as the owner?
You do not want to do that. So one
Because
of the
earnings become taxable.
Not that. So one of the important things to remember, the trust most people are going to have is third party.
Okay.
Able is first party.
First party, yeah.
So if we put first party in third party, we've poisoned the entire third party. and Medicaid will take all of it.
Yes, understand. Just want to clarify. I thought so, but want to clarify that.
Sure.
And I think one person was asking about like, can the special kid can have 529 as well as like able account? Can we do that?
Yes.
Yeah, he just answered that.
Okay. And just a general question, like since you are based out of Georgia, can you support or like a help if I am from Texas and then some other states? Can you able to help doing these things?
So we do help in other states. So what we will do is, we ask all the hard questions and help design the plan, help you choose guardians, trustees, build in the protections, and draft the special needs trust. At that point, we would contact an attorney in your state to make sure it's all in compliance with state law. The other thing we can do is really just do a consultation with a family, kind of talk through the structure, what they should think about, who are the guardians and trustees, and then they can engage an attorney directly in their state. But we can assist in some ways.
One last question. I think there was one question about the 401k savings and the life or term insurance benefits. Can it go towards the special needs trust or able accounts?
It can. Something that would be important when anything you're going to leave to the trust, you want to make sure you name the trust as the beneficiary and not the child, because you want it to flow directly into the trust. There are some benefits to leaving retirement accounts to a special needs trust or because the law changed a few years ago. You may be aware that something called the Secure Act changed minimum distributions from retirement accounts to a 10-year period, unless it's left to a special needs individual or trust. Then you have the lifetime of the special needs individual to take those minimum disbursements. So for tax planning, while before this change, you could just leave the percentages equally no matter what the asset. Now, for example, now my retirement accounts are more aimed at my son, but my life insurance is more aimed at my daughter. Because my son can take advantage of his lifetime for those minimum distributions. But if I left it to my daughter, she'd only have 10 years.
Okay. And your son is the one
with special needs. Yeah, I'm sorry.
Yeah. Sorry. Just to make sure.
Just one final question. I can just put it this way, unless if there is somebody coming up. I know I don't want to take most of your time. I know SSI you apply when they turn 18, right? And then they will get that money once it's approved. They'll get some 900 something you're getting. For a kid, can get any money from the government? That is number one. And is there any links available? What are all the available benefits from the government? Is there anything website we can able to refer?
I think so. As far as I'm aware, if the family's over income, right, not eligible as a family unit for cash assistance, it's going to be state specific, but I'm not aware of any cash benefit to minors, unless, parents have passed away, and that's a whole different conversation. The only real benefits to minors I'm aware of with special needs would be Katie Beckett. Obviously, things like you can get therapies through IEPs, IEP plans. Many states have special needs scholarships, where if the public school is not meeting their needs, they can get the cash equivalent to put towards a private school. So it's really would be in someone's best interest to look in their state for resources that might list state-specific benefits.
I think if there is no other questions, then I think okay, so that's a weird question. So the last question, one last question. If we send the kid outside of the country with guardian, So basically what they are saying is like they are sending the kids to the special need kids to the outside country. They are living basically outside. Can they continue to get the benefits if the kid is outside US? Okay,
Nope.
it's not possible. They had to be inside. Okay.
Yeah.
Okay. I think 12. I think there are a lot of questions comes. I think what we can do is like I can just summarize and then we can give it to you later.
Okay.
If possible, you can able to give that your answers back. And maybe most of our people they may want to review that existing their trust or something like they want to review with you. If you are okay, then we can send that details to you.
Sure, absolutely. So I can, I'll put my contact information on the screen. My email is always kind of the easiest way to get me. It's down here, dj@jlaw.com. And, we do a lot of our work by Zoom and virtually. So glad to review trusts or just do consultations, but glad to help however I can.
Thank you. Thanks. Okay, let's move on to that vote of thanks. இருக்கீங்களா?
Yeah, I'm here.
Thank you.
My name is Tamre Prabhakar. I'm former president of FETNA. Thank you so much, our judge and attorney D.J. Jayaraman. It's a wealth of information we got it from you today. It's not only for the special need committees or special need families. It's for whole people, for the whole family, for designing our future today and tomorrow. It's a wealth of information that you gave us. It's not only that, like our community, we have a different culture, different way of handling things, and different way of planning our future. And this will be very helpful to all the families to protect our kid and to do the will properly. At this time, I would also like to thank some of the non-profit organizations that I contacted. I'm seeing so many parents who joined through that organization. First of all, I would like to thank Innocent Bee nonprofit organization and Special Connections from Charlotte area. Thank you so much for all those parents who joined in this meeting. And also We Embrace from California. And Meena, I would like to thank Meena also. And also there are so many families from the Albany area that we contacted, and I think many of them they joined from that area. And also I would like to thank our local organization, Charlotte Tamil School and Tamil Sangam. There are so many kids that we have a special program for the special needs in our Tamil school also. So thank you so much for all the families who joined. I know there will be so much of anxiety, many questions, but we are not specific to any state or something. There are so many specific state-specific questions and so many questions that are very specific to your scenario that we cannot be answered in a 1 hour session. So just please contact us, contact FETNA through secretary@fetna.org or any of our volunteers. Please contact us. We will keep in touch. We have been doing the special need committee with a very useful committee, meetings like that, webinars for past for so many years, and this is one of them. So please give us support. FETNA is always there to help you. And not only that, apart from the language, we want to reach out to people about the language limit. That's why we have been doing this session in English, and anyone can join this session, hopefully to see all the families in the future session. Please be in contact touch with us, any of our volunteers, and you have a specific topic to be addressed for the special need families. Please let us know. We will make all the arrangements. And thanks to Ganeshan for arranging this from Atlanta area. And once again, from behalf of FETNA committee and FETNA board, I would like to thank DJ Jayaram for his time and effort and very patiently, answering all our questions. We know we have so much of anxiety parents and so many questions popping up still. But anyway, please contact us anytime. We will make sure that your questions are answered, at least in the future. Thank you all.
Thank you. Okay. So one more thing, just a quick thing before people leaving. If you guys want to be connect with us, like we are going to have like so many sessions like this, and then you may have a lot of questions. If you want to be, we are trying to create a new WhatsApp group. If you want to join, just send an email to our like specialneeds@vetna.org. That is our email. I just put it in the chat. Just specialneeds@vetna.org. So that is not going to be any marketing or any other this is just for our parents. We want to help our kids. Okay, if you have a question, I may have a question. So please, if you have something, send an email to this specialneeds@vetna.org. And thank you all. Thank you.
Thank you.
And thanks for the tech team
everyone.
for arranging this. Thank you guys.
Thank you.
நன்றிங்க எல்லாருக்கும். சிறப்பான நிகழ்ச்சி.
நன்றி.
மகிழ்ச்சி. நன்றி.
வணக்கம். நன்றி.
Ending the meeting now. Thanks everyone.
ரொம்ப தேங்க்ஸ் டெக் கமிட்டிக்கு கருப்பையான் சிவானந்தம். தேங்க்யூ ஸோ மச் ஃபார் ஆல் த ஹெல்ப். உங்க ஹெல்ப்லாம் எங்களுக்கு பண்ணிருக்க முடியாது. ரொம்ப ரொம்ப தேங்க்ஸ்.
Sure, I will pass the information.
Definitely.